Universal credit claimants, universal credit claim reviews, universal credit work coaches forcing universal credit claimants to produce endless amounts of documentation on what they have coming in as well as what they have going out. And yet again, from some of the comments I've read, clearly flouting the Equality Act of 2010 yet again. So let's get into it. Know your rights, and in this video I'm going to be breaking down what I believe to be incorrect by the Department of Work and Pensions. This is not legal advice. This is just my knowledge from working there as a former civil servant who successfully sued the Department of Work and Pensions, quite frankly, because they don't follow their own policies, and the majority of the people working at that godforsaken place don't even know the policies that they're meant to be following. And it's quite clear, looking at all of the comments, that this could again be one of those moments. So let's break it down by diving into a really concerning comment from one of my YouTube members. And if you want me to be pulling out one of your comments, going through it intrinsically, and even writing you a lovely little letter template, you can join the Justice Journals here over on YouTube. The Justice Journals website has a vast amount of information, templates, specialist areas, and you can even book a one-to-one with me, pending calendar availability, if you wish to. I also thank YouTube for giving me the opportunity to be the voice of many and help lots of people in the best way I can. And on that note, a little cheeky pun here. I have been nominated for the UK Health Radio Health Awards, which I was really surprised about. Yeah, basically, I don't know what to say. I'll leave the details all down below because the video is not about that. But I would appreciate your vote. It's just where I help disabled and neurodivergent people generate income online, help them with access to work applications, and quite often help people get amazing amounts of funding where they're being clearly ignored and discriminated against because they are disabled. So if you feel strongly about that, you can go along. I'll leave the link down below. Give me a vote if you want to. There are many people you could vote for over at the UK Health Radio. There are some amazing people there, you know. I feel such a teeny weeny person amongst some of the people that are in this. So yeah, anyway, as you can see, I'm slightly speechless on this note. So let's move on. So a very, very concerning comment indeed from Miss Ginny. And Miss Ginny, I'm hoping that is not your real name. So I'm going to be reading this all out. There is so much wrong with what you've been told, I believe, by DWP. So I'm going to be going through this really bit by bit, because it does affect all sorts of things, from being a student to reasonable adjustments, being disabled, LCWRA, and all the rest of it. So it's probably going to be a bit of a long one, but you know, I'm here to give you the facts and to help you guys out. And Miss Ginny, there's also a letter for you that I've popped into the member area as well. Okay, so Miss Ginny says, so helpful, thank you, and thank you for subscribing. Really appreciate that. I appreciate all of you subscribing, everyone, and all of your comments. It helps really alight the account, and it helps people like yourselves find these videos where you can get the help you need, and you know, be signposted to other places and other people where I can't help you if you need it. Okay, so let's get on. So helpful, thank you. I only started receiving universal credit in October 2024. This is about a year ago. However, they are conducting a case review, reasons undisclosed. I'm going to come to this bit afterwards. From 23rd of Feb to the 22nd of June 2025. They have requested all my account statements, including Revolut currency accounts. I was a mature disabled student which I disclosed in February. They now want my student finance letters. I'm feeling overwhelmed by all the information they want, and their reason was to see what I spend my income on. Am I obligated to provide my student finance letter if the February statement already shows my student finance payment? Furthermore, they are pushing the Back to Work programme. It's worth mentioning, apart from my disabilities, I'm also in cancer recovery. Dear, oh dear, oh dear. How shocking. Yet again, unfortunately, DWP clearly, not applying their policies here. First of all, Miss Ginny, I wish you all the best for your recovery, and I hope it's going well, and I really hope it continues to go well for you. Really, I do. So let's see what we can do to help you out here. So the first thing I'm going to start with is the case review, reasons undisclosed. That is completely incorrect, or let's just say not compliant, not lawful, in my opinion. And the reasons for that are this, and this is even stated in DWP's own guidance, but know that guidance is not the law. But seeing as they have stated it in their guidance, they should be following it. Now, when DWP do a case review, regardless of what that review is for, and I am going to tell you in a moment the different types, they must inform you of the purpose of that review. And if they don't, you should be asking it. And in the member section, there is a letter that I put in there this week specifically to request that. Again, don't do this in writing. On the phone. Do it in writing, and make sure you've got a screenshot of everything you upload to the journal. Now, DWP's own guidance states that DWP targeted case review guidelines and compliance interview guidance says the officer should explain why the review is happening, e.g., entitlement check, data match, suspected uncleared income capital, what information they need, how long the check will take, and what could happen if you do not provide the information. Like that, straight out of the door. And the fact that they're not disclosing this for all of you, and it seems just doing a blanket kind of request with non-disclosure, I think that is the main part that is wrong. You can't just request information willy-nilly and grill people, ask them for endless amounts of information, not give them a reason as to why, and also be dismissive about disability, because they're on a slippery slope here. Now, not that this is legal advice, but I can point you to two laws where you may want to take legal advice from going forward, and those are these. So the first one is under Article 6 and Article 8 of the European Convention on Human Rights, which is incorporated into UK law, even if it is from the European Convention, talks about fair trial and private and family life. So by requesting information that you consider to be intrusive, you could state that that does interfere with your private life by demanding personal records, and the interference must be, and this is the part where I think they're going really wrong, the interference must be lawful, necessary and proportionate. Now, if I was representing myself in this, I would say you cannot state that it's lawful because you haven't disclosed the reasons by which you require it, firstly. So therefore you can't there deem it to be necessary. And because you haven't done the first two, you can't really state it's proportionate either. So that would just end that straight away. Now, the next part, for your good self being in cancer recovery with other disabilities, is there are no reasonable adjustments here being made. It seems not. So you can request reasonable adjustments. You have to request them, and you do that in writing. The Equality Act of 2010 mandates them to make reasonable adjustments in the way they ask for information, in particular if you are disabled. And I would state, as you are at university, as you do have underlying other, lots of underlying health conditions and disabilities, that there would be a time period for which for you to be given to deal with this, right? To comply with what they're saying or requesting. Once you've established that you have to, that is the key. You don't have to comply with things that aren't lawful. Now, I have spoken in my last video, which I'm going to link down below. I went deeply into different case review types by the things that I can say, because obviously there are things I can't say, even though I don't work there anymore, but there are certain things I can't say. But there's definitely some things that I can tell you here. And that is this: when requesting information, in particular, what you spend your money on, they need to be sure that there is a law that allows them to do that. And the debt, the error or the fraud, the debt and the recovery bill is still a bill. It's not law. And it seems like they're going through processes right now as if it were law, asking, for all of this information. But Regulation 111 of the Universal Credit Regulations Act of 2013 and Section 109B of the Social Security Administration Act of 1992 state that information must be reasonably required to establish or check entitlement. So here I'm outlining this part here. You've already given them your student finance entitlement letter, which is going to state the dates and the academic year on. Now they want my student finance letters as well. Why? I would be requesting why. As long as you're not hiding anything, as long as you know that there's not something on those letters that is going to, not confirm something, then, I can't see any reason, for them to require it, because obviously the February statement already shows my SFE payment. What they might want to know, and this might be important, is the timelines. So Universal Credit is based entirely on timelines. So you could be entitled to Universal Credit on 1 month, but if you had funding from the month previous, or that might change your entitlement. So it might be something like that. Again, just be honest. I'm not saying you're not being honest, but if you've already provided that and they're saying we want all the letters as well, then I would argue back you don't require it, or I would request, for what reasons do you require it? Now, most importantly, not just for yourself, but for so many people in the comments, these two sections here clearly state that DWP only have powers to establish, or they have limited powers to establish income and capital and household circumstances. Who lives with who, how much money is coming into the household. It is not about expenditure. It is not about how much money is going out, unless you are self-employed. If you're self-employed, or you're a company, you have a company, or you're running a business, that is going to be different. But then you would be submitting that information every single month on your income and your expenses claim through your Universal Credit portal. And I can tell you now that the fraud investigation team most definitely do not like work coaches asking questions about expenditure. Reason being, let's just say you are under investigation for fraud and you've been asked all sorts of questions. Let's just say it went to court. Being asked questions about fraud from people who are not qualified, number one, could impede an investigation, and it could also affect the actual weight or brevity of that evidence. So again, very silly. So Currently, in law, from what I can see, and again, I'm not a lawyer, but there is nothing in law that states, unless you are self-employed or you have a business activity, there is nothing to state that they need to see what you're spending your income on. And that income in that point anyway would only be business expenses. It wouldn't be your personal expenses. So they can request to see what are you taking, out of your business income, but they can't necessarily request what is coming out of your personal income unless they suspect something fraudulent. Right, so let's get on to the bank statements. Can they ask for your bank statements, including Revolut or any other bank? Yes, of course they can. They are entitled to ask for bank statements, but that is to confirm income and capital, not what you're spending your money on. And if you have bank accounts in different currencies like Revolut and Wise, Wise is a borderless account, and I am, I recommend Wise. I leave a little link down below. Again, if you have your money in pounds and you put it into a borderless account in any other currency, it is a borderless account, then the European laws then apply. They can't simply go, requesting information from those banks if it's not in pounds. And even then, they would have to have a reasonable request to do so. And one of the reasons why I like Wise is because it's not like the typical high street merchant bankers that are going to charge you insane amounts of money if you want to transfer from one currency to another. They are the most competitive. You can access them anywhere. You can freeze your card, so it stops quite a lot of online fraud. That's another reason why I love them. And my own company had a meeting actually with Wise from Belgium a few months ago, and they have stated that as far as they're aware, they will not be given any information to organisations about the holders of the bank accounts unless they are mandated to by law, so Fraud, Money Laundering Act, all that sort of thing. So it seems to be quite a safe bank. And if you want to know more about the laws between like English banking and UK banking in regards to what organisations can look into, even if we go in, get the digital ID, there is a blog post which I've written. I'm going to leave that down below as well. You can go and read that, and that will give you some more info. Now let's dive into the student finance elements. Now, if you're receiving money, so income from Student Finance England, it depends on what you're receiving as to how that will affect your universal credit claim. Is it a maintenance loan? Is it a tuition loan, for example? Or is it a grant? Now, this might be one of the reasons why they want to see evidence from the letters. So the payment in your bank account will not necessarily say what it is. Maybe the piece of paper that you have given them doesn't necessarily say what it is, and they need to know the time periods that it covers for universal credit eligibility. So to be fair, I would say I would go with that one. I'll let them have that one. I think that's fair. Right, let's now tackle the back to work program. Fun fact on the back to work program: when I started working for Universal Credit, they took on thousands and thousands of people in the UK because we're in COVID times. Then they fired most of those people, or just ended their contract, actually would be more correct. They ended their contract after 6 months or a year because they said that all of these unemployed people that need to go back to work don't need a work coach anymore, because apparently the pandemic did not create insane amounts of unwell people and all the rest of it. Where did those work coaches go? They ended up working for the Back to Work programme. It's not owned by DWP, but it is funded by the government. And you get paid a lot more actually at the Back to Work programme, and you don't have to put up with DWP rigmarole. Anyway, Can they make you go to, or can they make you go on any program, but the back to work program? So you've been offered the back to work program because you have, you've been on universal credit, I should imagine, for a little bit of time. Now, it says there you started in October. You stated you started in October 2024. It might be because you've been on universal credit 12 months or more. I would be arguing, because normally back to work program is for people that have been on universal credit for a long time. I would be arguing this point. Number one, you're a disabled student. Number two, you would need reasonable adjustments. Number three, I would be working out whether or what's your entitlement. Are you on limited capability for work? Are you on limited capability for work and no work related activity? Because if you're in one of those, your work group is going to stipulate whether or not they can put you onto a program. Now, here's the rules on the program. The programs are there to support you. They aren't necessarily, I know they try and say that you have to do them, but if you're showing that you are studying or you are doing work-related activity, which could be doing your own work search, doing your own courses, there would be not an awful lot that they can do. So I'm surprised that they're forcing you on the back to work program as you are a student. One thing I will tell you is the government pay an insane amount for every single person that goes on these back to work programs. It would be interested who actually owns the company that runs all of that, and I wonder if they're connected privately to any large shareholder or top director at DWP. That would be interesting. But anyway, here is the black and white and the nitty gritty. If I was you, this is how I would argue it with DWP. You cannot be forced to do a program that is not reasonable given your health. When you have health conditions or you're disabled, it is you that decides the adjustment that you need, and it is you that decides what is reasonable. It is nobody else, and DWP's own lawyer even made that mistake with me. If you are in the limited capability for work and work-related activity group, you should not be mandated to do work-related activity at all. Now, there's a caveat to that because we've had lots of changes with the potential 4-point rule. The caveat to that is sometimes limited capability for work will say that you can do some work, that you are suitable to do some work, but not all work. And limited capability for work and no work related activity can state that you can't do any work, but if you want to do any work or work related activity, which could or would include studying, as they normally give you a license, you have to have a permit for that, and I think it's about 16 hours a week. So that is that other point. Now let's get onto the spending element. And I've aptly named this Your Rights. And I know it appeals to lots of people that are reading this or hopefully watching this, and share it out, guys, to anybody else so that they know their rights as well. You do not have to disclose your spending habits. Only income and capital, and as I said, a caveat to that is business expenses or business expenditure as well, unless you are under fraud investigation, and they will tell you that. You may need to provide your student finance letters. I've explained the reason for that, and I do think that's pretty fair. But you can push back if you think they've already have enough evidence. If you think what's already on the letters is in the information they already have, then I would be saying to them, why do you need that? Justify why the letter is reasonably required, and use that term, reasonably required, because these are all terms that are in the acts and they have to comply with the law. Now, as somebody, and this is for anybody really that's got a long-term health condition, might have cognitive issues, maybe you're neurodivergent, maybe you're disabled, you have the right to ask for all communications in writing via Universal Credit Journal. One, as a reasonable adjustment. You might be on medication, which might affect your memory. You might be neurodivergent. So sometimes for neurodivergent people, if it's out of sight, it's out of mind. And for some people who are dealing with multiple things, or maybe you're just that type of a person, you retain information better and more if it's written down. That would be the reasonable adjustment part of it. I would also say, because I think the Department of Work and Pensions are the most dishonest department I've ever had the misfortune to have a dealing with, and how I see they misuse, in my case in particular, information to try and put themselves at an unfair advantage. We all know one of their strategies and tactics is to pressurise people verbally. We've seen it in PIP assessments and all sorts of other things. Now, the minute I get into any sort of serious situation myself, or, you know, not get myself into, but I have anything to deal with seriously in my business, I refuse any communication other than written. And if you speak to anybody that is legally trained, they will tell you there's very good reasons for doing that. So, you know, you do, I would, you know, do what you want to do, but I would suggest that if you're unhappy with all of these things, because you stated so more too in your comment, that you just request that everything is done in writing. It also helps regulate your emotions, right? If you're not having to deal with it like feeling pressured and you know you don't agree with it, but they're pressuring you, you might end up saying something that you might regret. So it's nice. It takes away that emotion, gives you that breathing space. You can go and get advice, come along to the justice journals or whatever, and just check out your facts. And I like everything written down because my disabilities, I have to deal with lots of things digitally, and if it's all written down digitally, then I can recall it very quickly, or even just find it sometimes. Right, you can also request a reasonable adjustment, as I said, under the Equality Act of 2010. Now, this is your right, okay, if their demands are overwhelming. Now, if you're feeling overwhelmed, that's the measurement. That is the measurement. It's you that sets the quota. It's nobody else. For example, extra time, clear explanation on why they need extra time or limited repeated requests. And do not accept if they say, well, you're studying, you're clearly very clever or intellectual. I've had that from DWP's barrister as well. That would be direct discrimination right there. We cannot assume just because somebody is intelligent, I can't even believe I'm having to explain this, but that, you know, that they don't need a reasonable adjustment. But unfortunately, even DWP's legal team have stated that, not just verbally to myself in a case management meeting in front of a judge, but they've also had the stupidity to put it into writing. So don't accept that either. And because I'm hyper organised and I like little action lists to go through, I've done one for you after this 20 odd minute long video. Number one, you need to be requesting a review letter. You want to know exactly what the case review is for, check what it says, and ask for the reason if it's unclear. Number two, bank statements and statements only provide what's relevant. Income, capital, not spending. That is not relevant, it is not proportionate, and there's no reason for it because there is no law to qualify that they can ask for that unless the case review reason states otherwise. I'm going to end up disappearing in a moment. Number three, student finance, give the award letter if asked, but question if bank proof is enough. Again, state the reasons why. And then for the health and work programme, request reasonable adjustments and check if the back to work programme actually applies to you. and use these words. Is it mandatory that I attend the work and health programme? Lots of work coaches are going to say yes. Then you need to say, can you point me to the policy where it states that, please? And make sure that that is clearly a government policy and not guidance, because the two things are not the same. And then you need to make sure that your reasonable adjustments for your health have been taken into account and that you feel that their decision is proportionate and fair in regards to your reasonable adjustments. And if it's not, well, let me know and that will be another video. I'm going to leave that one there up on the screen. Bid you all a wonderful day, and I hope this is helpful. It's time to take back your power. Know your rights, guys. Know your rights.